Is a new Utah self-defense law improving our justice system or leading to unintended consequences? It is a question the KSL investigators have been asking since the law went into effect last year. Tonight, Daniela Rivera joining us to break down how the law has been used. Daniela?
Well, Mike and Ashley, the KSL investigators have tracked every known case affected by this law in its first full year. We've heard from people impacted. Now tonight, we're sharing our analysis with you so you can decide how the law is working. Gunfire that left an 18-year-old woman paralyzed.
He was stabbed.
A man murdered by his roommate.
Brutally horrible. It was horrible.
And protesters met with a taser and pepper spray. What do these cases have in common? In each one, the accused aggressor tried unsuccessfully to use a new Utah self-defense law to get their charges dismissed without going to trial. Last year, House Bill 227 sailed through the Utah legislature. The law gives people who are charged with a crime and claim self-defense an opportunity to ask for a justification hearing. Prosecutors then have to prove the person charged was not acting in self-defense in order to take the case to trial. And defendants can still claim self-defense again at trial, just as they've been able to for decades.
They want to have a free bite at the apple up front and then have a second bite at the apple later, and they want to call it as justice.
Salt Lake County District Attorney Sim Gill has been a vocal critic. He says the new law forces judges to make a decision meant for a jury and creates an extra hurdle for prosecutors and victims.
Unnecessary burdens which re-victimize victims and cost taxpayers money over again for a problem that did not exist.
A jury never saw this video from back in 2019 of a truck ramming John Michael Clara's SUV from behind. Clara says he then fired 7 shots in self-defense. One of those bullets traveled through another nearby truck, narrowly missing a child. Clara urged lawmakers to pass the new self-defense law.
This law, if it were passed, it would help people in my situation.
Then he used it to have his scheduled jury trial canceled and this justification hearing held instead. The judge found the situation troubling, but said the new law forced a ruling in Clara's favor.
As I say, I believe my hands are tied, and I have no choice, given the statute, but to dismiss the case.
I support Utah's new self-defense law.
Defense attorney Mark Moffitt says people who've acted in self-defense should not have to invest time and money in a jury trial. And if prosecutors have a case they can win at trial, they shouldn't have an issue disproving a self-defense claim early on.
And if a person is sitting in jail on a homicide charge where there is a valid and legitimate claim of self-defense, that person ought to have the ability to have that issue resolved early in the case.
Moffitt says this new law marks a return to a time in Utah's past when cases were more thoroughly vetted during hearings early on in the court process.
It's in this very limited, narrow slice of cases that involve the use of self-defense.
The KSL investigators analyzed dozens of Utah court records from the first 365 days that House Bill 227 was in effect. We found 52 defendants requested a self-defense justification hearing under the new law. 7 requests were denied because the cases involved domestic violence, so the law didn't apply. 11 cases either moved forward or were resolved in other ways, such as a plea deal. 10 cases are still pending. In 22 cases, judges sided with the state, either ruling the defense didn't qualify for the special hearing or that prosecutors presented enough evidence to disprove a self-defense claim. In just 3 cases, defendants successfully used the new law to get their cases permanently dismissed without going to trial. And judges in 2 of those 3 cases voiced concerns, including the judge in Clara's case.
This case is, in the court's view, a classic case that should be decided by a jury.
They even urged prosecutors to appeal their decisions.
Almost rare, unheard of, where a judge would say that.
If the courts are concerned about ambiguities in the law, they have legislative liaisons that can reach out to the legislature.
Our research shows Gill's office has prevailed in the majority of the self-defense justification hearings held in his district, but those cases are often delayed by months. He's now calling on the legislature to revisit Utah's self-defense law.
Are they going to pay attention and take seriously the collateral consequences of their decisions? Do they care about victims? Do they care about justice? Or is it just lip service? I guess we'll see.
Prosecutors followed the judge's guidance and appealed the ruling in the case against Clara, and we are closely following that appeal. Mike and Ashley.